everybody. Thanks for waiting. Today, the special guest is Professor Joe Potuto. Thank you for being here.
Thanks for having me.
Sure. Do you want to tell us what you're doing these days?
Well, at the moment, I'm in Florence, Italy. I'm here on what's called a living and learning adventure. I'm taking or will be taking 20 Italian lessons over the 45 days. It's 3 hours a day. Half is grammar, which I'm pretty good at. Half is listening and speaking. And there I need a lot of help. So I'll also be doing a little touring. Tomorrow I will go to Fiesole, which is a really cute little town not too far from Florence. This evening I went to a concert at the Santa Croce Church, which has a lot of great art. And it was a concert of Gregorian chants. And Gregorian chants I happen to love, but they really are, you either love them or you hate them. I don't think there's any middle ground with a Gregorian chant. And that was really lovely. And then Sunday, I am going, I think, on the tram. This is part of the group thing, to hear another concert. And what is it? Zebi Mehta will be doing the conducting. So that's my little week in a nutshell. Had 5 classes already. Part of the group I'm with is doing beginner Italian, and they only go 4 days a week. So they were out shopping today. Somebody just had arranged to have a leather jacket made, and she bought this most gorgeous red leather purse. I mean, it really is gorgeous. So that in a nutshell is what I've been up to.
Oh my gosh, that's all in 1 week. That's pretty
Yeah.
impressive. You're living the high life.
Well, it's actually a lot of fun. It's rained the last 3 days and it's cold, and I don't think I brought enough clothes for the cold weather. And I don't know whether it's in Florence or in Tuscany or in Italy, but there is a regulation or law, don't know which because I don't know what the jurisdiction is governing it, that you cannot turn the heat on until sometime in mid-November unless a government official decides, well, it's too cold and you can turn it on sooner. So I'm already cold. And I don't think I managed clothes well. I think I was just assuming it would stay warmer longer, and maybe it will once the rain finally recedes. But it's a little apartment. It has everything I need, except, would you believe it, there is no corkscrew here. So I have to go out and buy a corkscrew. I can't imagine that an apartment in Italy would not have a corkscrew, but this one doesn't. So.
Did you learn how to say it in Italian? How do you say corkscrew in Italian?
Oh, I have no idea. That's a good question. I have no idea. I just point.
Wow.
It's got to be vino something, I'll bet. Wouldn't you think? I'm going to look it up while we're talking.
Yeah,
I'm looking
this
up.
True. Thanks to Google or all those different apps. Yeah. So, yeah, I just assumed you were doing something legal in Italy.
No,
like
no,
teaching.
I don't do international anything. A corkscrew is a cavatappi. 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 So now you know.
Thank you. Thank you, Yala. Okay.
No, I am doing a couple of legal things, but I'm doing them over Zoom or through Word. But so there's nothing local here that I'm doing that's law related.
Mm-hmm. Oh, okay. So, do you still teach some classes?
I'm not teaching a class of my own this year. I may decide next year to do that again, but this year I didn't want to. But I am doing some guest lectures in classes for other professors. But that's it's not a big time investment to do that. That's what I'm up to with teaching anyway.
Yeah. Okay, that's great. Well, of course, everybody wants to know your opinions about Donna Adelson's case. So I think you already saw the recent, what do you call it, affidavit regarding the Gmail account.
Yeah,
you
I
tried to
did. I
flash that
did.
up. Yeah.
Uh-huh.
What did you think when you saw it?
You know, a couple of things. One, it surprises me that they hadn't gone after that much earlier.
Yeah.
And I
Same
don't know
here.
whether, yeah, excuse me, go ahead.
No, I was just agreeing with you.
Yeah.
Yes.
So I don't know whether that means that they didn't have the phone, which seems to me to be a little peculiar, or they didn't think there'd be anything on the phone, so they didn't look. And then they acquired other information that prompted them to look. I actually don't have an explanation that makes much sense to me.
Mm.
And I have thought about it. I just, there is the one, I don't know, I guess I would say interesting part about all this is if you recall the hearing at which Daniel Rashbaum withdrew as counsel for Donna. When Alex Morris got up, at one point in his presentation to the court, he said something like Charlie asked if he had his phone. Do you remember that?
Yes. Yeah. People
Yeah.
have been mentioning it.
And that was a peculiar comment at that hearing, I thought. I mean, it didn't relate to anything that was at issue at the hearing. It just seemed very odd and stuck out then. And so now we have this, you know, affidavit and a request of the court to be able to, I don't know what the right word for it is when they go into a phone and acquire, both data in terms of the actual content, as well as a list of, who was phoned and when. I don't know, I guess I'd call it an index. Uh, and that comes right after, the comment that Morris made. So it leads you to believe that the two things are related, but beyond that, I have no explanation. I have a hope that they will find additional evidence in this search that will give them some, other leads. Certainly to build a case against Donna, maybe something against Wendy or Harvey. Um,
Mhm.
if they find anything against Charlie, unless his conviction is reversed, there's no need to use anything against Charlie. He's already in prison. So it's tantalizing. And maybe somebody smarter than I will be able to figure out what in the world is going on, but I really can't offer much insight.
Yes. And you're very smart. You're
Well,
both
thank
at
you. But
the top of your class at Rutgers Law School and editor of the main law review. So
uh,
yeah. So Top Cat has a good comment. I agree that towards the end of this, that's where they say they didn't know about this email until this year, I guess. Here, this is where they say.
can't see the whole thing, but
Oh,
yeah, but that's what's so peculiar. How could they not?
mhm. Yeah. So
You know,
these emails were not located in any other device or
right,
search warrant previously served. Yeah, because
right.
you would think that the FBI had the power to just generally ask for, any
Uh-huh.
sort of emails that
Yeah. Well,
that
they have
Charlie
to have
might have.
probable yeah, they have to have probable cause that they're going to find evidence in them, but uh, they're prosecuting Charlie, now they're prosecuting Donna. The emails can be relevant, and they wouldn't know which phone relevant incriminating emails might be on. So if they've
Mhm.
got the probable cause and the opportunity to look at one phone, I don't know why they wouldn't have the same opportunity to look at all of them, because you don't know where you're going to find it. I just have no explanation for this. Hopefully, somebody will explain it at some point, because it's
Yeah.
just clear.
Yeah. Well, I don't think they don't even really need Charlie's cell phone to be able to find his emails, though. You know, shouldn't they have the ability to, I don't know, subpoena or contact Google first, just to say, hey, look up any accounts that Charles Adelson has with you? I mean, I
Yeah,
thought they had that power.
yeah, going directly to the provider. Yes. Now we're getting to an area where that's out of what I know a whole lot about. But I thought that Google, and not just Google, but the phone providers resist those sorts of things. I have this vague memory, and maybe somebody in your chat will have a much better memory than I do, or you may, Judy. But I have this vague memory that at one point, and I don't know whether it was the Adelson case, but it was certainly a case in which law enforcement was looking for evidence from Google, and Google resisted, and they have some sort of, technology is not my forte, trying to block the opportunity for them to get it. And it took a while, and then I think law enforcement found an end around to get in and get the information. So I don't know what Google's position will be in all this, but I do believe that in the past, Google just didn't merrily turn over records without, and this should be enough if they get an order from the court, but I guess we'll see. But in any event, to think about them and think they're there now, I mean, it's just whatever it is that they now know that leads them to believe they're going to find it, is I just don't know. But I guess the more important thing is not so much why it took them this long, or what it was, what it is that they have now that led them to go after this. The more important thing is whether what they'll find will be helpful in the prosecution of Donna and or Wendy and Harvey.
Yeah, that's right. So again, it's sort of like a blessing in disguise that Donna's trial got postponed. But
Could be.
It's like, why is it taking so long to get this info? But, whatever, as long as something happens.
Well, the other thing it obviously shows is they are continuing to investigate. They're not just sitting on their hands, resting on the evidence they already have, but they're continuing to poke and look, which you would expect. You would expect law enforcement and the prosecutor to do, but this is a nice little confirmation that that's what they're doing.
Yeah. So who knows? Maybe there's going to be more incriminating evidence against
Wendy. Well, you would think that at worst, nothing comes of it, right? And after that, anything else is going to be additional evidence. So
yes. Okay.
Fingers crossed, right?
Yeah, we're still optimistic, aren't we? Despite all the frustrations.
I know.
Years.
And I'm wondering on the hearing whether Alex Morris either will withdraw or whether Donna is looking for somebody else to represent her. And although I hate, excuse me.
Oh, no, go ahead.
I hate, since I can't see you, I can see the information that you posted, so I'm not getting any clue from you that you're about ready to talk, which is why I've now interrupted you twice. So I apologize.
Oh, it's all right. Go ahead.
Yeah. I've got mixed feelings about her changing lawyers, on the one hand, it will inevitably delay when this trial starts. I think inevitably, because anybody coming in will know less about and have spent less time with the case than Morris did. On the other hand, I continue to have a concern, excuse me, about a lawyer who was involved when Daniel Rashbaum was involved in the representation, continuing as counsel or lead counsel for her. So either way that goes, for me, it's not going to be 100% happy day to find out what the answer is to whether she changes lawyers or stays with Daniel Rashbaum. Oh, excuse me, with Alex
Morris.
Morris. Yeah.
Yes. I'm just totally guessing, but I have a feeling she and Harvey could still be shopping around for attorneys because they've jumped around from attorney to attorney in general. So, nobody's ever good enough, I guess, but, or maybe the attorneys are telling them things they don't want to hear.
Yeah.
So
Yeah.
I'm just
Well,
guessing.
that would be what, shades of Sarah Boone trying to control every lawyer that tried to work with her. Yeah, I mean, it certainly could be that they're looking for somebody else. And from her perspective, she hired Daniel Rashbaum because she thought he was, the best going. Alex Morris came on the case only because Daniel believed he needed somebody local and obviously needed to divide up the work. I mean, the idea that he would carry an entire murder prosecution on his shoulders without having another lawyer in there that could share some of the load. Among the decisions he made that I thought were just odd, that was one of them, that he didn't think he needed somebody, apparently didn't think he needed somebody to share the load. So, it's not as though, at least from our end, from what we can tell, it's not as though she made a lawyer search and picked Alex Morris. He came on because Daniel selected him and she trusted Daniel. And that's not to say that Alex Morris isn't a fine lawyer. From everything you hear about the lawyers who know him, he is. But she didn't go pick him. She inherited him because Daniel Rashbaum had hired him. I'm sure he consulted with her, but I mean, it was really his decision. So now it's not unreasonable to think that she would want to take a wider or deeper look as to who she would want to represent her. I'll be interested if she does switch lawyers, if she decides to go back to Miami rather than find a lawyer in Tallahassee.
Oh, that would probably be a mistake, I think,
I do
given
too,
what
but
happened with Charlie. Yeah.
right. I do too. Not having somebody local. And it's, I don't, it's not that, at least my view is, it's not that, oh, the lawyers for this case in Miami would be less capable, less competent, less diligent, or any of those things. But they really don't know, the sort of the legal scene in Tallahassee. And, I guess part of it is, the rapport with a jury and whether they really relate or seem to be one of us to the jury. But it's really more than that, because a local lawyer will know the judges, will know the, sort of the routine in terms of how the legal practice goes. We'll know the prosecutors, we'll know the investigators of the prosecutors use. They'll just have, that local lawyer will just have a better feel for how the process works in Tallahassee. And it isn't that you can't do a fine job without it, but it makes it easier when you know the people, particularly if you already have a relationship with them. If you're a lawyer with whom the prosecutors have worked, they believe that you are somebody who is reasonable, somebody, if you say, I will get something done on day one, or I'm planning to do A, that they can trust what you say, and that's worth a lot. So as I said, so it seems to me it makes sense to find somebody from Tallahassee, but if she's looking, I wouldn't be surprised if she brings somebody in from Miami again, or for somebody somewhere else other than Tallahassee.
I see. Okay, Sequel has a question for you. What's your thought about when Donna was arrested, the policeman took her purse, her blue travel bag off her shoulder and just gave it to Harvey? I thought that
Yeah,
was weird.
I thought that was odd. When you make a search, you have the and you've got a warrant. You have the usually have the option to seize anything that's on the person of the suspect, and that would include that shoulder bag. Um, they evidently didn't think she'd have anything in the shoulder bag that was going to be evidence that they would use against her. Maybe that's a good guess. I mean, they're more experienced than I about investigative processes, and it may be a pretty good guess that she wouldn't be carrying anything on her person that would be incriminating when she's about to board a plane at the airport. It particularly maybe since she at least had to be concerned that she'd get arrested as she tried to get on the plane. I mean, she had that conversation with Daniel Rashbaum, evidently, about, could she get on a plane and what would happen. So maybe it's a, reasonable guess that or decision by the police that there wouldn't have been anything in that bag that would be evidence. But I did think it was odd.
Yeah, because she could have had a notebook inside,
Yes, she
because
could have, but
she'd
they're
left
probably right.
notebooks.
If she at least maybe doesn't believe she's going to be arrested at the airport, but at least realizes it's a possibility she could be arrested as she's boarding that plane, that she wouldn't put a notebook or anything like that, in the carry-on bag that she's taking on the plane. If she had anything like that, it seems to me the only reasonable thing for her to have done would have been to burn it or throw it in the trash or something. I mean,
Yeah,
the idea
chew it
that
up.
that's right, chew it up.
Tear it up.
I mean,
Yeah.
the idea that you would retain something that could be evidence against you when you've had all these years to get rid of anything that at least any hard copy of anything or anything, I don't know what the a map or whatever that would relate to the crime. Uh, it just doesn't seem to me that a sensible criminal would do that.
Yeah. Fancy has insider sources. So she's telling us that she heard the state intends to object to Morris representing her going forward. So thank
Well,
you, Fancy. What do you think
uh,
if this is true?
well, I thought that the state should have objected to Rashbaum in the first place. And so if they now are worried about any taint, then I think it's exactly the right thing to do. I mean, the Sixth Amendment right to a lawyer of your choice, if you can pay for that lawyer, is a very, very important right. Courts do not want to intrude or interfere with that right, and rightly so. But the defendant and the state, you and I, also have a right to assure that there is going to be a fair trial in the case, one that does not lead to a reversal of a conviction on appeal. And in that case, for her to say, I waived the conflict is fine and dandy on her side, but we have a right to say, we're not sure that's enough. We're not sure that there isn't still a potential for an ineffective representation of you. And beyond that, we're not sure there isn't still a possibility that this will end up in a, not going to trial because Charlie withdraws the, the consent. And I thought, and I've listened to a lot of the commentators since. I think everybody back when said it was a bad idea for Daniel Rashbaum to represent Donna after representing Charlie, after representing Donna and Harvey. I don't think any lawyer that I heard anywhere who had any knowledge of this case said anything other than it was a really bad idea. I think a couple of people who looked at this said they thought this would be this was going to lead to trouble and it would be a reversible error. I think Carl Steinbeck may have said that, and I think Stephen Weber early on had said that. But I think, looking at it, what happened, I've said this before, what happened was that Daniel Rashbaum, Donna, and I think anybody looking at it believed, Charlie's waiver was Charlie's waiver. He would never go back on it. He would never, first of all, he wouldn't do anything to hurt his mother. But in addition, there wouldn't be any particular reason why he would do that. So I think everybody lost track of Charlie. And I think that was demonstrated by the fact that the judge twice went through with Donna, are you sure you want to do this? And went through those questions. But, excuse me, nobody ever directly talked on the record to Charlie or reconfirmed that he was prepared to continue with the waiver. And so I think everybody, in a sense, dropped the ball, including the prosecutor. And it sounded like, from what was said at the hearing by Georgia, that they thought that it was solid. They took representations by Daniel Rashbaum that it was solid. Now, I think that's what he believed too, that it was solid, and that Charlie would never, go back on the waiver. So everybody's got a little fault in here. I said before, and I continue to say, the major fault is Daniel Rashbaum's, because he should have had the good sense not to do it in the first place. And I worry because the appellate lawyer in this case, who everybody says is a very, very good appellate lawyer, when he talked to Charlie, evidently told him, you've got at least a shot at a reversal of conviction here, or maybe post-conviction relief, and you don't want to risk that by getting on the stand and saying anything. So I think about the trial, and I at least didn't see anything that happened at the trial that would be reversible error. In other words, a big enough mistake at the trial that an appellate court would say, gee, without that mistake, we don't know whether the jury would have convicted. It's that big a mistake. I didn't see anything like that. So the only thing I can imagine is that the appellate lawyer thinks this business of Daniel Rashbaum representing Donna, then Charlie, may provide a claim as to, ineffective assistance of counsel because of the conflict. And I guess that's where, if I were to try to guess what the claim is going to be, what the appellate lawyer thinks gives Charlie a shot, I think it's that, which only makes this that much worse. If Charlie could succeed on that, because the problem is the conflict in terms of the representation doesn't start with Charlie agreeing that Daniel Rashbaum can represent Donna. It starts with Donna and Harvey agreeing that Daniel Rashbaum can represent Charlie, and that there's no conflict anywhere in all of that. So, this case, it's like the gift that keeps on giving. It's been long and drawn out. We all know that. And partly it was, the COVID years when nothing was going. Partly it was the hung jury with Katie Magnabua. I'm pronouncing it wrong now. But yeah, I have to have it written out in front of me in order to get the pronunciation. I don't have it written out here. Partly it was that hung jury, which was, unexpected. And it was that one juror who didn't want to put both parents of children, didn't want to have anything to do with both parents of children being imprisoned. So that delayed it. And so, and then you've got the doing them, in sequence. And if there is ever a trial of Wendy, they're going to have the immunity issues, which I assume are going to take some pretrial time, because her lawyers are going to claim that you can't prosecute her because the evidence will be tainted. And so they're likely going to have to go through what the state is going to use. I mean, I would be very surprised if there isn't some pretrial time before, you can get to Wendy. So it's a real, there's nothing good of something that takes this long to get fully resolved. And partly, of course, it's the number of defendants that have extended this, but there's nothing good that comes from all this delay. I said nothing good. I guess I should take that back and say technology has certainly made a difference. And they were able to get more out of the wiretap, or not the tap, but the bugging, and be able to make more sense out of what was said. And that certainly is a benefit. And of course, after, Katie then decides she will provide evidence, and each time they find something out because of the last trial. But I don't think what they've been finding out trial to trial is enough to outweigh all the time that it's taken.
Right. Yeah, this is such a great teachable moment. Like, don't you feel like this could be a whole law school class by itself?
You could certainly do a lot with it. Certainly the issues of the representation, you could spend several classes on, what goes on. And some of the trial delays and the decisions to do one defendant at a time, a trial practice course could certainly look at and analyze. With regard to the substantive legal issues, those aren't as full of teachable moments in a class, because there's nothing particularly unique about the kinds of things that were happening during the trial. So some of it, yes, how technology works, how experts can put a case together. An evidence class could certainly spend some time with the arguments about the presentation that I'm blanking on the name of the investigator who did
Isom?
Isom. No, not Isom. The investigator who did the technology, who was able to. Yeah.
Yeah.
Certainly an evidence class could look at that, how you use an expert, what makes an expert as compared to a fact witness, what's the difference between a demonstrative aid that you can use in the court during the trial, but doesn't get to the jury. All those things, I think this case would be very helpful to students to look at, because they're concrete. So I guess teachable moment, maybe not the way to describe it. It would be, pieces of things that different classes might be able to focus on and use. And certainly the conflict issue, the issue of the representations and what happened there, of course, on professional responsibility, could certainly spend some time with. In terms of the issue with Rashbaum going from one client to another client to another client, like, jumping. I think of it as the James Bond movie when it was Sean Connery. I don't remember which one it was, where I think it was the crocodiles or the alligators in the water, and he had to get to the, to the shore to safety, and he just hopped from one back to another to get out. And that's the way I picture what happened here. What happened, but something that happens in law school, I think, is a little illustrative of this. When students are in a course on professional responsibility, that is the rules and the ethical obligations of lawyers, they are very good at spotting issues and spotting places where there likely is an issue or there might be an issue, spotting places where they would say a lawyer, even if a lawyer could, a lawyer shouldn't do something. But you take that same student and put that student in a criminal law class or a criminal procedure class or an evidence class and present the same hypothetical, and they're much less likely to see the professional responsibility or the ethical issues. The focus is what helps them find them. Now here there was certainly a focus, but the focus wasn't on Charlie.
Okay. Yeah. Can you see what I put on the screen?
I can only see it's sitting on, unless I can move it. Maybe I can move this. No, I can't. It's only sitting in the top left-hand corner.
Oh, okay. I'm sorry. Yeah.
So it's not
this
centered.
Oh, okay. So it's coincidentally, I just got this email today from, I think it's from the local bar. So Stephen Steen, who has been interviewed on this channel and created a
He has
lot
the
of
book.
controversy.
Yeah.
Yes. So apparently he's been invited to speak at this Domestic Violence Month CLE class, which is October 30th, 3 p.m. So, I mean, I'm thinking of being there at least virtually. So,
that's interesting because he wrote that book early on.
yes.
Yeah, I don't remember. It was after the first trial. I don't even know that it was that he had published that book after Katie's trial. I thought
Yes,
it was
after
after
Katie's
Katie's
trial.
also. Okay. So unless he's been keeping up, and maybe he has, some of what he talked about is going to be stale, and there's going to be all kinds of new information. Plus, I heard him interviewed saying, because it might have been on Surviving the Survivor, I'm trying to think where, but anyway, it was an interview where the person interviewing Epstein said, well, will you write another book when this is all over? And he said, no, I'm moving on. I wrote a book, and that's it. Somebody else can write the next one. So it's interesting that he is prepared to participate or do a CLE lecture on what occurred.
Yeah, I'm curious to see what he's going to say because, when he was being interviewed, he gave the impression that he was kind of through with it, that, he was moving on to write something else. So, yeah. But,
well, and he had said in the book, because I did read the book, as I recall, that he didn't think Wendy was involved. And then I heard him say, again, it might have been STS, whatever the interview was, he had said that whatever he said, that comment was based on what he knew at the time. And he sounded as though he was saying that, on new information, he was at least rethinking, or at least not prepared to continue to say, I don't think she was involved. And that, if there's new evidence that came in, then of course he might have to revise his opinion. So it might be interesting to see what he'll say about that question, or if he gets that question, what he's prepared to say. I suppose I was going to say if he'll say anything, but if he's doing that CLE and he's not a lawyer involved with the parties, he would have no reason not to comment. about the case.
Yeah. Or the fact that she has been named by the
Right.
state as a co-conspirator.
Right.
Yeah.
Right.
Because that's just a statement of fact. So
Right.
it's not
Exactly.
anything slanderous. Yeah.
Right.
So anyway, very interesting. Oh, did you have a chance to read that case that I emailed you?
Yeah, I did. The case
Rashbaum's.
where Daniel Rashbaum represented a defendant who then claimed after the conviction that he really wanted Jose Baez.
Yeah, for $650,000, but he didn't have the money because the
Yeah.
government put a list
Yeah.
pendens
Yeah.
on his property.
For the people on the chat, there was a person who was prosecuted, and what happens it's most often in drug cases where the FBI, because those are often federal prosecutions, will seize things that are traceable to the crime. So they'll seize the car that you use to transport the drugs, and they'll seize anything that they can show. Somebody paid you $100,000 for the drugs. They can seize the money if they can show that it was traceable to the drug crime. This was not a drug crime, but it was the same sort of thing. The feds had traced or had arrested him, and then they didn't seize it, but they put a notice on it, and the notice said, anybody who wants to buy this property should know that there's ongoing litigation about it, and you're buying the litigation too. So, for example, it's a lease pendens is the term for it. If that's placed on my house, and I want to sell my house to Judy, she would see that there's this notice that says there's litigation. She buys the house knowing that, and if the litigation means that the plaintiff wins, then she's lost the house, even though she paid me for it and I'm the one against whom this plaintiff had the claim. She took that property knowing that the plaintiff in the case, in this case, government, said, we've got a claim on the property and it's superior to yours and you better know it. So the defendant in the criminal prosecution said, that means that I was, people didn't want to buy all this property that I have because they were afraid they were buying, something that they weren't going to be able to keep. And the fact that I couldn't sell it meant that I didn't have enough money to pay for the lawyer that I wanted to have. And what he said after the trial was the lawyer he wanted was Jose Baez, not Daniel Rashbaum and Rashbaum's firm. Daniel Rashbaum.
How insulting. Is that
I know.
insulting?
That's what I thought. It was really kind of funny. But he said that after the trial. And what happened was the court that looked at that, the appellate court said no, because there's nowhere in the record when you were complaining, and this defendant complained over and over again that this notice was on his property and it was inhibiting his ability to, to get a lawyer and do other things. But nowhere did he ever say that the lawyer he wanted was Jose Baez and not Daniel Rashbaum. And in fact, according to the court, there were at least a couple of times when the defendant, when he said he didn't have enough money, said he didn't have enough money to hire Rashbaum because he had hired him to do the pretrial stuff and wanted him to do the trial. And Rashbaum said, unless you can come up with the rest of my fee, I'm not doing it. And so this defendant had said, gee, I can't hire the lawyer of my choice. But at the time, at least a couple of times, said the lawyer of his choice was Daniel Rashbaum. Then it became Jose Baez, and Jose Baez provided an affidavit to the court saying, he wouldn't take the case because the defendant couldn't come up with the money that was owed. So it was, as cases go, although it was very long for the amount of information you got out of it, it was kind of funny. And you're right, it was kind of, insulting that Rashbaum's defendant after the trial said, gee, the person I really wanted was Baez. But, defendants generally are not firm friends. And as soon as they're convicted, they can quickly decide that you, the lawyer who represented them, was part of the problem, or maybe a big part of the problem, and forget that maybe the biggest part of the problem was the fact that they committed the crime in the first place. Judy? Have I lost you? Judy?
Sorry, I was on mute. Uh-oh, she disappeared. Oh my gosh. I hope she comes back. Can you guys hear me? Okay. Yeah, I think she must have clicked on something thinking she couldn't hear me due to something on her end, but hopefully she'll come back. Okay. I need people to help me due to my voice problems as usual. But the good news is I got an earlier appointment to get a Botox injection in 1 week. So, okay, here she is. Oh, I'm sorry. You disappeared. Thank you for coming back.
I know. I have no idea what happened. First, I didn't hear you. And then then I lost you entirely. So sorry.
Oh, yeah, I was just on mute. I should have clicked on my little microphone thing. So, yeah, so what were we discussing? Oh, yeah, I was mentioning that it seems to happen a lot with family law clients too, where at first you're like their godsend. It's like, oh,
Yeah.
you're such a great attorney. Oh, I'm so glad I have you. But then if they lose or they feel like they lost, then it's like, oh, you didn't do this. Why'd you do this?
Yeah.
Why didn't you say this? Why I wasn't prepared, And I'm like, well, what about you changing your story on the stand?
Yeah, I don't know where I was cut off, but I said that, it happens a lot. And what they seem to forget, that the biggest problem that led to the conviction is probably that they were guilty of the crime to begin with. That's the part that they seem to lose touch with.
Mm-hmm. It's like, how about you not commit crimes and do stupid stuff that got
Boy,
you caught?
is that true? Or evil stuff. I mean, this last few weeks, I'm a very late night person, and I'm up in the middle of the night, so I often watch, tapes of some of the programs like yours, Judy, or I will watch a tape of a trial that happened during the day. And boy, this last few weeks between Sean Diddy and Madeline Soto has just been so depressing to me.
I couldn't even
depressing.
stand to watch or read that stuff. Yeah, crimes against children. Yeah,
it's terrible.
I don't want to hear about it.
Terrible. And that's another trial where, I am really perplexed that they have not decided to go after the mother, because I counted up the evidence I thought there was against her, and I thought it was enough to get to the jury. And I am very persuaded that if it got to the jury, they'd convict. But that is I thought about that case and that child, being, I don't know what you're allowed to say on YouTube, and I don't want to get you in trouble, but.
Yeah, you might have to spell out things.
Yeah, I guess. So let me say, the victim of SA since she was maybe 8 years old. A life where she says that what she wanted to do was go live in the woods by herself. It's just, and then he kills her. It's just awful, awful. So this hasn't been a good 2 weeks for me. That's why I guess Sarah Boone, now that's a terrible murder also, but at least, you don't want to say there's comic relief when you're watching, a trial or a program where they're discussing somebody has been killed, and particularly the way that victim was killed. But I can't help, there is comic relief in the way it occurs. And maybe that's the way go ahead.
Yeah, because she acted in such a despicable way after it happened, and thanks to Florida sunshine laws, we get to see Sarah Boone in all her crazy glory, just it was not intentional. It was not intentional.
So it was.
I need my Dr. Pepper.
I know.
Please let
Well,
me
she
get my
now,
Dr. Pepper. Oh,
I know, well, she now says it is because she's
what?
claiming, uh, 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 domestic, I don't know how to, I don't know, DA, I don't know what to do.
Yeah,
I'm
being
I'm
abused.
not accustomed to having to spell out things. I mean, I will say that the idea that you have to spell out words when you're dealing with a trial, when the trial is about the thing, just seems to me to be an odd editorial position for YouTube. Just odd. But in any event, she's now changed her mind about that. But when I'm talking about comic relief, it's going through the number of lawyers writing 50-page letters to the judge, putting that. I don't know if you looked at the advertisement she posted when the judge said she
No.
was going to have to. Oh, you should. Well, read it. The
Oh,
judge finally said, "You've had 8 lawyers. That's enough. I'm treating this as you're deciding to go pro se. No more." And she writes an ad that goes for pages asking for a lawyer to come represent her. And it's just, I mean,
wow.
the way she writes, she's a pretty intelligent person, but yeah. So, I guess comic relief is the way you can sort of stay sane looking at all this,
Well,
misery that people are creating.
what kind of cases did you handle when you were a prosecutor?
Well, I only did prosecution. I took a sabbatical from teaching to prosecute. And my aim at the time was, major aim was credibility in the classroom because, I knew a lot about the criminal process. I had several friends who were prosecutors. I had seen some trials. I had talked to them about it. But I thought from the student's perspective, teaching it would be better if I can say I've done some trials. So that was my major aim going in. I found when I went into the prosecutor's office that I just loved doing it. So it was only there for about 16 months. They asked me to stay and I decided to go back to teaching. So I got in, I think 1, maybe 2 juvenile trials and 7 felony trials in that time. And I did little grand jury work. I did a couple of preliminary hearings. I did some what they call in-service, which is training of investigators and detectives on, Fifth Amendment, Sixth Amendment, Fourth Amendment issues. I did a policy revision of the office in terms of how to move things. I did some witness interviews, which were, I thought, a lot of fun. So, and so I didn't, the last trial I did was an aggravated assault where the defendant, there was an altercation in the bar and the defendant just pulled out a gun and shot the victim. And the only reason why and he was paralyzed for life. The only reason why it wasn't a murder case is the bullet didn't, was just a little to the right of what would have killed him. And I was thinking of that case when Charlie's verdict came in so fast, because in that trial, the question was whether it was a question as to whether this was the shooter. I mean, there was no question that whoever was in the bar did the shoot, or outside the bar. I guess they were in the bar for the argument, and then the shooting happened outside the bar. But in that case, and as an aside, I don't know if everybody knows this, but wherever the courtroom is, certainly in the state, the prosecutor's office is right next door. The public defender may be a little ways away. Private attorneys may be anywhere where their office is. The prosecutor's office is right next door because you're running back and forth if you're a prosecutor. And in that case, I started back to the office and somebody came running after me because the jury was in. It was 5 minutes. And they had come in with a conviction. And then I went down to the cafeteria for lunch and there were several of them still there and they wanted to know some of what we weren't able to introduce at the trial. But what I learned, one thing I learned from that was I had another trial in which the father of the defendant testified, and he was just the most likable person you would ever want to meet. Just gregarious and just, I mean, it was just wonderful. And he lied through his teeth on the stand. And what I learned from that was we had evidence that was suppressed that we could not enter in the trial. And it was sitting at my desk. And so when I say he lied, I know he lied because I had this evidence that was irrefutable, demonstrating that that father lied. And I watched him testify and said, I believe every word he's saying. So what I learned from that is, at least for me, and I think for a lot of us, the ability to catch someone is certainly, for me, it wasn't as good as I thought by any means. And it made me much more wary about when you're putting evidence in, which is why I guess I have some sympathy for Georgia and what she's doing, because, that experience of knowing he was lying and still being completely persuaded by him was a demonstration about when you're on the prosecution side and you have to prove it beyond a reasonable doubt, you have to be really careful that you have enough, really careful. The only other thing I would add to that is, because I thought it was necessary for credibility and I did the whole gamut and I really enjoyed it. But at the law college, and I think at most law colleges, when we have, when you have practicing lawyers come in to teach trial advocacy, once in a while they teach evidence law. Sometimes you have them do, a variety of different things. They typically are not the best teachers. And I always thought it was really good to have them come in to teach because it at least made the students aware that those of us on the resident faculty who could teach, had a skill set that was useful to them, even if not everyone had been in a courtroom and done the thing. So it was a very helpful, sort of
Mhm.
contrast for them.
Yeah. Well, I have a question for you then. So can you explain to us how the whole grand jury proceeding works?
Sure. Not every state has a grand jury. Federal government does. In order to start a prosecution, a felony prosecution anyway, there has to be probable cause to believe that the person you want to put on trial did the crime and probable cause to believe that the crime happened. So there are two things that you have to have probable cause about. And a judge can't simply announce, I find probable cause. The Constitution requires that there be some independent entity that decides, yes, there's probable cause. So there are two ways that can happen. One way is called beginning a prosecution by prosecutorial information. And in that system, the prosecutor puts together the information, and then there has to be a preliminary hearing at which the evidence is presented and the judge says, yes, there's enough for probable cause. And for those of you who remember Perry Mason, all his cases ended in preliminary hearings. They never went to trial. He was always able to cross-examine witnesses and do all kinds of things. That isn't what happens at a preliminary hearing, but you got to have enough. Grand jury is the alternative way to do it. Historically, there were 23 people on a grand jury. You needed a majority in order to say there's probable cause. The grand jury would indict, and that's the document that says we believe there's probable cause that there was a crime and that this guy did it. And 12 out of 23 was not done indiscriminately. It was 12 because the petty jury, that is the jury that was going to hear the trial, had 12 people. In a grand jury, you do not have to have witnesses who are fact witnesses about what occurred. And you do not have to present evidence that would be admissible at the trial. So what usually happens is the lead investigator comes in. I think a lot of people in the chat have seen warrants. And you had something up, with regard to the investigator Newland in Donna Adelson's case where he says this happened and this happened and this happened. He obviously isn't the one who saw any of those things happen, but he's recounting what witnesses have told him, and he puts it in a document. That's effectively what happens at the grand jury. He would get on the stand and say, so-and-so said this, and so saw this, all hearsay. And that's what would be presented. And if he wanted to say, and here's the evidence that was taken when we searched the house, even if the house was searched without a warrant and you could never get that evidence in a trial, that could go in at the grand jury. And then on the basis of the hearsay and what might be unconstitutionally seized evidence, the grand jury decides there's enough to go forward. Defendants do not appear before the grand jury typically. Defendant's lawyer is not there because the only thing the grand jury is doing is saying the prosecution side has enough to bring this to trial. That's the way it works. Now, I will add that although I said you could do it, could put in all kinds of unconstitutionally seized evidence and, all of that, and then the grand jury would indict. Prosecutors don't do that. Unless it's an exceptional case, because you have to prove that case beyond a reasonable doubt to the jury at trial. So you can't simply throw in all this evidence you can't use and expect that at the trial there's going to be a conviction. So there's a real check on it happening, but in theory it could. So grand jury proceedings are secret. You don't know what happened. You're not, the defendant is entitled, if the defendant does testify before the grand jury, the defendant is entitled to a transcript of what she said there, but is not entitled to see a transcript of everything that happened at the grand jury. And the grand jury was designed to be a protection for suspects, because you're going to have your, people, your peers, people who are not associated with law enforcement, people who do not have a stake in the game of getting you prosecuted or convicted, making the decision. That is the theoretical underpinning of the grand jury. In practice, what's often said is a grand jury would, indict a head of cabbage,
Yeah, or
they're
ham
inclined to
sandwich.
come in, they're going to, that's right, whatever they're going to indict. And in fact, there are cases in which, often they're political cases, where the prosecutor does not believe there's enough to go forward, but it's a high profile case, and the prosecutor's office doesn't want to take the heat for choosing not to prosecute. So the prosecutor will go before the grand jury, but try to persuade the grand jury not to indict. And it's very difficult to even when a prosecutor doesn't want you to indict, for the grand jury, to get a grand jury to refuse. Grand jurors can ask questions when the detective is on the stand or anybody is there. They have the right to ask questions and get more information, but they're really there. If you think about it, it's not the reason why it's not a adversarial process is you can't have a big blown adversarial process at the stage at which all you're trying to decide is there enough to bring this case to trial? And at trial, you're going to have the full-blown process with a jury there hearing the case. So it's just sort of the trigger to get going. And I see somebody said ham sandwich. That's probably the right quote, not a head of cabbage.
Yeah, I
Same
remember
idea.
that. Ham sandwich. Wait, so did you say the defendant does or doesn't have the right to be there?
Usually it does not appear, but the prosecutor can bring the defendant in to testify before the grand jury.
Oh, okay. I don't know why I
Possible.
thought it was all secret.
Well, it is secret, except the defendant is entitled, if he does appear, to get his, get his information. It's not, it's very, very, very uncommon, but because it's up to the prosecutor to decide what evidence is needed to get the grand jury to bring the case forward. And of course, the defendant's going to have a Fifth Amendment privilege.
Yes.
So it's got to be an unusual circumstance.
Yeah. Okay. So it's kind of like a very lopsided mini trial without the rules of evidence.
Yeah, except that's That's not a friendly way to describe it from the prosecutor's point of view. It's
Okay.
lopsided because that's the moving party saying I have enough to actually bring it to trial. I mean, you don't, for as an example of that side of it, you don't bring the defendant's lawyer with you when you're interviewing a witness, because that's you may show them you may have to provide it in discovery afterwards, but they're not along to ask their questions and maybe make the information you're trying to get from the witness less available or less helpful. You're building your case on this side, and you don't bring in the other side to work with you when you're building this case, whether it's criminal or civil. So.
Okay, thank you so much. Yeah, I was just looking at the time. It's already past 6 o'clock. So yeah, so I just ask people if they have any last questions for you, because it's such a treat to hear from someone who is a constitutional law scholar who is not Ben Graber. Do you get the joke?
Well, yeah, I do. That's a really low bar. My God.
Better than Ben Graber, telling everybody she needs to be set free.
Yeah.
Get her out of jail. She's a nice lady. She deserves to be at home. Yeah. Oh, here's a question. Here's one question. Have they heard of the Adelson case in Italy?
I guess I have two answers to that. One, I doubt it, but two, I don't know. I don't know the extent to which, it's certainly not on television. To the extent I can figure out how the television works, it's not on television. They may have YouTube here, and then it's possible, but I can't get YouTube on this television, so I have no way of confirming it.
Oh, okay. Yeah, I don't think I've seen anyone from Italy commenting on this case.
Well, you have now.
Oh, yeah. Well, but
in
because
Italy,
you're
in
there
Italy.
visiting. Yeah. Yeah. Okay. So Katie Cool Lady, one of your number one fans, she says, does Joe have an opinion on the state being successful, arguing against Morris remaining as Donna's attorney?
I haven't really, I didn't know, or I hadn't thought about the state this time actually arguing against it. I guess I would say, I don't think he should I don't think that he should be permitted to do it. I think there's a pretty good chance they could succeed on this, in part because they've got the problem of the Donna's case now not going anywhere because of the issue of Rashbaum's conflict. I think if it's going to happen at all, the judge this time really has to have a hearing in which at which the question whether Morris is completely free from any information that Rashbaum had that would relate to Charlie is not there. And I do believe that they should have, if they're going to do it, some way to also have the appellate lawyer for Charlie there. Because what happened at the trial, not the trial, the pre-hearing, if everybody remembers, was initially what occurred was the appellate lawyer comes in and says, this is a problem because there's the potential of privileged information. That was their initial position before they got to the hearing. And Morris says, well, we always thought that might be an issue. And so we built the Chinese wall, or the barrier, and I was kept out of all of this. And so I can go. And then the lawyer says, well, no, we then looked at the rules more closely. And the problem is the relationship, the lawyer-client relationship, it's bigger than the attorney-client privilege issue. It's the lawyer-client relationship and that trust relationship. And Daniel Rashbaum, still in the trust relationship, there's a problem, even if he doesn't do that cross-examination. I thought after that, certainly not the day of the hearing, thought about that more. And I've asked some lawyers since, and I don't know of a situation in which you are the principal lawyer for a client and you can't do a cross-examination. And in fact, you have to be excluded from what that cross-examination will be. I mean, it just, sure, in a trial, you and I, Judy, may divide up. I'll do witness one, you'll do witness two. But this is a case in which they were saying, I, who am the lead lawyer in the case, cannot know what you're going to do about witness two. You've got to do it independent of me. I've never heard of such a thing. So I thought it was a problem at that hearing, and I thought the judge taking, however, I didn't take much time to assure himself that Morris had been excluded, that it was sufficient. I wouldn't, I think the state is right to push this because I don't think that should be enough. I mean, think about it. You wall yourself off. Does that mean you're never talking about the case? There's never leakage? There's never a possibility that, and how would you know? If you don't know what Rashbaum knows, how would you know if you've heard something that you shouldn't have heard? So I think it's the cleanest way to go. And that's why I think it's probably a better than likely chance, because you're risking doing this again, and nobody wants to do it a second time after having done it the first time. And Donna's saying, I thought the most extraordinary thing at the hearing was Donna saying, you know what, he's essentially this, the third lawyer that they brought in, the really supposedly outside person. He's told me that he's going to be unprepared when he cross-examines a witness against me, and that's fine. I waive that too. Well, that's when you're getting into the state's right to assure a defendant has a fair trial. That's independent of your right as a defendant to have any lawyer you want. We wouldn't let you come in with a lawyer who's been certified as maybe a severe case of Alzheimer's, and you come and say, that's the lawyer I want, and I have a right to pick anybody I want. We would not allow you to do that because you would not get a fair trial. And you can't waive your right to a fair trial. You may want to, I don't know why, but you can't do it. And then you have the consequences that, of having to go through this again, bringing witnesses in, all of that. So I think maybe it's a really good question that Katie asked. My guess would be better than even.
Okay,
But
thank
it's
you.
going to delay the trial more.
Yeah, I'm just thinking if because it still kind of looked like Donna was nowhere near as close to Morris as she was with Rashbaum.
Right.
And there was people were showing pictures where Donna gave this like pissed off look.
I think that's just her facial expression. I don't think it means anything.
Expression now. Yeah. But
well,
anyway.
I would say this time what I said last time. The cleanest way to do it would be for Morris to look at it all and withdraw. Then there's no Sixth Amendment claim that Donna will be able to raise on appeal because her lawyer has decided not to proceed because his assessment of the situation is such that he thinks there might be a risk, which would have avoided it all if Rashbaum had done it the first time.
Yeah. So
and
more
that's to say,
delay.
Right. I mean, I don't know. I obviously don't know Alex Morris, and everybody speaks very highly of him. And I am sure that he's being pulled because he's got, I'm sure he feels a responsibility to Donna. And if he withdraws, it's going to delay that case even more. And she wants that trial to happen So I'm sure he's being pulled because of that.
Okay, this is probably a quick question. Do you think federal judges should be confirmed with a simple majority or party line vote?
uh, trying to think what that.
Yeah, isn't it a majority? I don't even remember. I'm sorry.
Yeah. But what happened? Judges. Let me say, judges, one way or the other, no matter what the system, all come out of the political process. There are different ways they get there. In some states, you vote for a judge. I happen to think that's not a good way to select judges. But in some states, you vote for the judge. In other states, they have what's called a modified Missouri plan. The people vote for the judge initially, or no, the judge is appointed initially, and then there are retention votes every few years. And if some of your chat people are old enough to remember this, in California many years ago, there were judges appointed by, oh, I'm blanking on his name. I'm not doing well with names today. It will come to me anyway. He's a very young governor at the time. And he had appointed, I think, 3 justices to the Supreme Court. And they had made some rulings that a lot of the public and some lawyers thought were novel. In fact, one of them was the subject of a movie. And the ruling was when garbage became, when garbage was no longer yours and therefore the police could take
Oh,
the garbage.
yeah, privacy. Yeah.
Yeah, and two or three of them were subject to recall votes. 2 of them, I think 1, maybe 2 were recalled. And after that, the Supreme Court moved to a position that was more in line with other states. And after that also, because California, at the drop of the hat, they have constitutional amendment. The people amended the Constitution of the state of California to say that essentially that the Supreme Court of California could not make a ruling on the Fourth Amendment that was any broader than what the Supreme Court of the United States would do. Typically, a state can have a broader view of a constitutional right under its own constitution, but that whole situation, 1 judge for sure, maybe 2, lost their seats on the Supreme Court, and then there was a constitutional amendment telling the rest of them, you can't do some of this stuff. So it's all so that's I said you can be elected. It's the modified Missouri plan. And then the federal way, which I think maybe a third of the states do, is that the governor or the president nominates, and then the elected body confirms. So no matter which way you look at that, it turns out to be in part a political process. And the check is, I guess one of the major checks on this is not so much that maybe you've got, a heavy Republican majority in the legislature. So whether it's a, simple majority vote or a 2/3 vote or whatever it is, you're going to confirm. But that over time, the political dynamics of a legislature change so that you may get some judges at this point, but over time, you get a different view. And I would add that on the trial level, the district level courts, usually, not always, but usually the decisions are within a range of reasonable. I mean, one might lean this way, one this way, but I don't think that you see serious politics entering into, certainly not on the criminal docket. Not impossible, may happen sometimes, but we don't live in a perfect world. So whatever bad result you think can happen, whether it's the judiciary or not, on occasion, in some places with some judges, will happen. It doesn't mean the system is wrong. It means that we're not perfect and we're not going to have universally perfect people making the decisions.
Mhm.
End of
Yeah.
speech.
Okay. Okay. Thank you. Okay. Maybe one last question because I do have to get going also. Would the state be talking to Morris about withdrawing? I don't, do they even have that authority to do
Yeah,
that?
well, you know, the state and the defense can talk about anything, but I don't think they'd be talking about this because that would look as though, you know, depending on how that was portrayed, as the state pressuring a lawyer to withdraw, and that would look like it was intruding. That's right, Jerry Brown, thank you.
Jerry Brown.
Would look like
Thank you.
the state was attempting to interfere with the defendant's right to choose her own lawyer. It's different if the state does it in an open hearing saying, here's the law, you know, here are the facts, and therefore, judge, you should not let her make this choice, than saying to a lawyer somewhere on the corridor, you know, we don't want you to do it. I mean, it's just, I mean, it could be portrayed badly even if it wasn't done with a bad purpose and wasn't done in a way that was illicit. It's still better on the record.
Mhm.
But thank you,
Yeah.
everybody. I'm glad everybody
Yeah.
else has better
Thank
memory.
you.
Well, I'm not glad you have a better memory than I do, but I'm certainly glad that you remembered here.
Oh,
Jerry Brown, yes.
yeah. Well, these are all just questions out of left field while you're on this glorious vacation in Italy. So thank
No,
you
I
for
am
taking
doing some
time.
work, but it is also, that's right. You know, here I am.
Oh, look, somebody says, I think it was Justice Rose Bird of the California
I think
Supreme
she was,
Court.
but yeah, it may be just one. I mean, I haven't looked at that in a long time. So, you know,
Wow.
my memory in general is correct, but on the particular, you know, facts there, it's going to be off a little. I mean, I did say part of that related to the death penalty and the reversal of death penalty cases in Florida, but the people were just, you know, unhappy with what that Supreme Court was doing, and boy, did they, boy, did they affect the trajectory of the court.
Yeah. Okay. Oh, she wants to know where are you? Do you feel like
You're going to
saying
come
that?
after me? I'm in Florence, and my apartment is directly behind Santa Croce, so it's in a really nice section of Florence. It has everything it should except the corkscrew, as I say, which I cannot believe. But I found a dollar store, and tomorrow I'm going to go in search of a corkscrew.
Oh, great, great. Well, do you still have any relatives there, like people to go back to see?
Not in Florence. My family is from the poor section of Italy. We're from southern Italy. Uh, so I have some maybe second cousins or second cousins once removed in a little town above Salerno. And I think my father, I might have relatives through my father who maybe are in Rome, but I haven't seen them. My mother kept in touch with everyone, and her Italian was much better than mine, so it was easier to keep in touch. But
Uh-huh.
there are
Yeah.
some, I've got more in France because the town my family was born in or comes from was extremely poor, and people who could emigrated somewhere. So a group emigrated to the French West Indies, and then as the children went to college, they all went to college in Paris, and then they
Oh,
stayed in Paris or, you know, around or in France somewhere. So I've got a lot of relatives in France.
oh, okay. Maybe
My
you
French
need to
is
go
worse than
there.
my Italian, so, you know, but their English is good.
Oh, that's great. Okay. Well, thank you so much for your time and hope you
Sure.
continue enjoying your travels. So thanks,
Well, I'm here.
everybody.
I'm going to stay here I'm going to do a little traveling, but mostly I'm going to stay here for 45 days. And I
Wow.
still will watch these trials and things because, you know, I'll probably be able to catch live. Actually, I might be able to catch live a little more than I am when I'm home because of the
Oh,
6 hour time difference. And, you know, 9 is 3 here, 10 is 4. That's easier for me than
mhm.
9 is 9 because I don't like mornings at all.
Oh, okay. Yeah, same here. So,
I do them,
yeah.
but I don't like them.
Yeah, yeah. Okay, well, thank you guys for caring. It was kind of like dense legal topics tonight, but hey, some people like it, and you make it fun and interesting. So, yeah,
Well, thanks for
so
having me. This was fun.
sure, it's always a pleasure. Okay, have a great weekend then.
Thank you. You too.
Take
So
care,
long.
everybody. Bye.
Bye.